What you're looking at here is two inherent jurisdiction cases which I started by ex parte docket and grounding affidavit. This one is HIA 2024-190, which concerns criminal misconduct by court staff, Garda members. This one here is HIA 2024-191, which concerns criminal misconduct committed by a county register and the Chief State Solicitor. So, these are inherent to the High Court. The High Court has accepted them. There's no fee on them because under Article 40.3, the state guarantees to protect and vindicate her rights. And when they concern criminal actions committed by state employees, this statutory instrument, 492/2014, cannot be applied. So this statutory instrument only concerns civil law. This is criminal and constitutional law. But I was able to get orders from Justice Cregan on the 14th of October for both cases to allow them to proceed. I decided then to issue two plenary summonses for these cases. This one is 2024-6852 HP. And this one is HP 2024-6645P. These plenary summonses is the beginning of the plenary process, which is a statutory procedure in Ireland. I'm trying to hold these court service staff and the county register and the Chief State Solicitor accountable for personal wrongdoing and criminal misconduct, right? Now, I have initiated a notice of motion, which is going to be before the court on the 22nd of October. For both cases, this was originally to be before the court in March, but the judge kept kicking it down the road. And it's back now before the court on the 22nd of October. So these motions are going to remove the state protection that's been funded for these state employees because it's contrary to Article 40. There's no legislation allowing for the state to fund a legal defence for employees who've committed personal misconduct and criminal wrongdoing. But that's why it's so important to challenge these individuals and the institutional mechanisms that are there to protect them from being held accountable. And the only way we can do that is by entering the High Court, exercising our constitutional rights under Article 34. We're allowed to enter the court of first instance and bring any matter before the sitting judge, who has a constitutional duty to administer justice in all matters of law, fact, criminal or civil. So that's Article 34, subsection 3, 1 degree. And when we come into the courts as citizens of Ireland, we have enhanced protections under Article 40, which is our fundamental rights, to be treated equally before the law, and Article 40.3, to engage the state's guarantee to protect and vindicate our life, our person, our good name and property rights. By doing that, the state can make sure that none of us is deprived of our personal liberty save in accordance with law. Personal liberty is sequential in protection. In terms of the state's obligation to make sure that they protect and maintain it, as it is inherent to the Irish citizen, and the state is responsible for upkeeping it. So if you're around the four courts on Wednesday the 22nd, do come into court too. I'm in front of Justice Cregan, and I'm going to stand on my constitutional rights and assert my right to hold these people, these individual people, accountable in the courts, the county register, the Chief State Solicitor, court service staff. There's a principal register in there as well too. These caused false imprisonment. They deprived me of my liberty. These ones deprived me of my personal liberty, and I'm going to hold them personally accountable in the courts.